So thank you all for staying for our final panel. We appreciate it. We hope that you're glad that you did and that we can offer some new insights into our industry. I think all of us, or at least most of us, can agree that litigation finance is a valuable asset to law firms and their clients. I think most of us can also agree, or at least those of us who are practicing litigation finance every day, that the actual process of obtaining litigation finance can be uncomfortably slow, perhaps unreasonably difficult, and occasionally involve some unexpected surprises. So this panel is dedicated to exploring the causes for those delays, the difficult issues, and perhaps anticipating some of what those surprises are. But before I try to frame up the issue, I'm going to ask my panelists, who are all wonderful, and by the way, who are all in the trenches, in the coal face every day doing litigation finance, to introduce themselves, starting with Michael Kelly on my right.
Good afternoon, everyone. And again, thanks for sticking around. Really appreciate you being here today. And thanks to the law school for organizing. It's been a wonderful conference. So really appreciate that. So I'm Michael Kelly. I'm a partner at the law firm of Parker Poe, based in their Washington, D.C. office. I've been involved in litigation funding transactional work, primarily in the aspect of doing the actual transactions themselves, but also in the fund formation side for a lot of litigation funders. I've been doing this for about 10 years. Litigation funding initially was a very niche and very small part of my practice, but it's 100% of my practice today is in this industry. And I've had the chance to represent funders of all kinds, from investment banks through traditional funders, family offices, high net worth individuals. Also represent, of course, a large range of funded parties, from individuals to small companies, to very large corporate, even some publicly traded companies doing litigation funding transactions as a funded party. And then we also represent a large number of law firms, either because they're representing plaintiffs who are being funded, or where they are actually the direct recipients of financing. So we have a team of us that in Parker Poe who work on this sort of almost full time. There's 5 of us. Which I think bespoke sort of the growth of this industry. It's been really quite remarkable and quite exponential. So I was a little bit concerned. I think Andrew sort of set this up confrontational, and during the very short break, I saw Chad and Erica coming out with boxing gloves on. So I was a little bit concerned that it might get caught in the middle here.
Trying to keep it exciting.
Exactly.
So please, Erica Levin.
Hi, and again, I want to echo the gratitude. Thank you to the Center on Civil Justice and to NYU Law School for having us. And I know David and his team worked tirelessly, and so thank you. So we're almost there. I have to confess, I thought there were drinks at the end. I'm not sure that there are, but I really appreciate you staying. My name is Erica Levin. I'm a partner at Fox Rothschild in New York. I practice in the international arbitration space and litigation finance. Way back when, you wouldn't think that you could say you do both, but I do. So I do a lot in the transaction space. I also do some work in the diligence space. Along the lines of what Michael's saying, we tend to work on some things together, and we definitely brainstorm a lot, all of us, in terms of the transactions. I tend to represent the funded party. That's what we've agreed on is the way to call the counterparty. So the client and or the law firm who is accepting the advance of funds to pursue a litigation or an arbitration. So that's usually where I am. I also do work with funds a lot in terms of other aspects. My background, I way back when worked in the litigation finance industry a long time ago as general counsel for an entity. But and I've had this experience over the years. The litigation funding market continues to evolve. Where I sit a little bit uniquely at this table is I sit as counsel, I sit as an arbitrator, but I also have the insight of my robust general counsel's office within my firm, which is about 950 attorneys, 27, 28, maybe 30 offices. So I get those calls too. So I see all the different vantage points. And part of the brain trust for this program and this panel in particular is to talk through some of the clauses that we see, some of the contracts. And litigation finance negotiating can be easy. It's not always easy. The ones we see tend to they tend to close. Why? Because we're informed and we're educated. And sort of the thought behind this was the more that we educate, the more that we talk, maybe the process could be more streamlined. So there you have it. I will now pass it along to Chad.
Jack Schirmer.
Hi, I'm Chad Schmerler. I am the Senior Managing Director and Head of Litigation Finance at Pretium, which is a $50 billion alternative asset manager. Before that, I was a partner at Norton Rose Fulbright, where I ran the litigation department in New York, chaired the firm's global litigation finance group. And I've been doing this for the better part of 12, 15 years. I was with Tony and some others here, part of a working group in the ABA that created the ABA's white paper on litigation finance more years ago than I can remember. And since then, I've been representing funders, the firm's clients, and now my own selfish interests at Pretium doing litigation finance. So that's my background. Why don't we just get right into it?
Thank you all. And I'm Andrew Langhoff. I got into this industry about 10, 11 years ago. I was originally the COO of Burford Capital. I went to Gerchen Keller Capital, but for the last 5 years, I've started something called Red Bridges Advisors, where I help those who are seeking to obtain litigation finance to work with various funders and to close deals. So I'm going to start with 3 quick observations just to take some things off the table that cause delay, but really aren't in our remit. The first is to remind you that litigation finance, the process really has 2 parts. There is the legal due diligence, and then there's the transactional component. The legal due diligence is multi-layered, iterative, can take months and months. We're not going to discuss that. That's on our table today. We're going to talk about the transactional elements, the deal documents, and arguably the term sheet as well. 2, most litigation finance transactions are multi-million-dollar transactions, and that inherently slows them down. They have lots of scrutiny, lots of approval, complicated economic terms. These are not things that are unique to litigation finance. They'd be true of any loan or investment. We can't solve for that today. We're just going to have to suffer that. And thirdly, litigation finance is filled with bespoke issues and often issues of first impression. As I say, I've been doing this for 10 years. I've never seen the same deal twice. These unique features are embedded into the contracts. This might stem from the nature of the claim. A key tam deal is going to look different from a mass tort deal. It might have something to do with the parties themselves. A Fortune 500 company is going to look different from an inventor in a garage. It might have to do with the jurisdiction. It might have to do with task aspects. There are lots of different reasons that these deals are bespoke and different. And even in first impressions, I have a deal this week with something that is brand new to me, it's brand new to the funder, and it's brand new to the counsel who's been working on it, who I know has done more than 300 transactions. So there are reasons that these deals are complicated and difficult. But putting those aside, there are in fact a number of aspects that are in almost every litigation finance deal that can cause delay if they're not anticipated. And we're going to try to address those right now. We'll do it in 3 parts. First, we're going to try to take those difficult contractual issues that frequently come up. These are usually near and dear to the funders' hearts and completely new to the funded party who's never done litigation finance before, because they are unique to what we're talking about and they often cause conflict. So we'll take a look at those. Then we're going to do a lightning round, if you will, where aside from contractual issues, we're going to try to look at all the other reasons that we have delay in these transactions. This will function almost like a checklist for anyone who does this to say, these are all the things that you should talk to your client about before you get into the transaction. And then finally, based on all the above, we're going to explore this question of whether or not there's room for a standardized agreement for litigation finance or something akin to that might be able to address some of these delays and some of these difficult issues. So with all of that, let me jump right in. So with respect to these difficult contractual issues, let me set this up by saying the example we're going to use is going to be a plain vanilla litigation finance deal. It is a single case, fees and expenses for the plaintiff deal. Can't get more basic than that, right? And as we go through these 4 or 5 topics, I'm going to ask one of our panelists to sort of stand in for the funded party and one to stand in for the funder. Don't hold it against them, please. So the first issue is sort of near and dear to my heart. You know, we probably spent most of the day talking about litigation finance as non-recourse, right? And let's be honest, we market it as a non-recourse product for the most part, commercial litigation finance anyway. And yet, when the client finally gets the first draft of the contract, one of the first things they'll tell me is, Andrew, you said this was non-recourse. There are all these recourse bad boy provisions and indemnities and all sorts of reasons that I have reason to worry now. This is not nearly as simple as I thought it was going to be. What are we going to do? So I'm going to ask Michael Kelly, when you get that phone call, Michael, within the realm of what's reasonable or what has to be accepted or how to basically prune that, what advice would you have for your counsel?
So I think just preliminarily, I'd say we sometimes find on the funded party side, there's really two types of clients. One, they're not interested in reading really the document at all. They're really desperate to get the financing and they just want to get the deal done. And they're not so concerned about some of the terms here. So in that circumstance, my job is really to point this stuff out, right? Because there may be a presumption that there was only going to be, payment to the funder out of a successful case. But, as Andrew is alluding to, in fact, we have recourse provisions in every funding agreement of some kind. And they tend to vary. Some can be fairly draconian, some can be more focused around truly sort of bad boy kind of acts, we'll call bad boy acts, which are more intentional or with knowledge. And funders in their documentation use quite a broad range of type of recourse language. So depending on exactly the language that's in this transaction. Thank you. Thank you. Is this better? Yeah. So depending on the type of language that's in a contract, I have to point out to my client that and try to explain to them why it's important for a funder to have recourse in certain circumstances. But of course, they're very worried about the fact that, well, what if I breach the contract? I don't really mean to do that, but it's sort of an incidental kind of breach. Are they suddenly going to come after my home? Are they going to come after, something that's important to me, my other assets? So we have to walk them through that a little bit because sometimes the language is that broad. Breach the contract and it's become a recourse, transaction. Of course, there's other, more obvious ones as well that, there could be, some misconduct. There's been an effort to try to misappropriate some of the funding. There's been an effort to kind of divert or give alternative instructions to counsel as to where the proceeds should be paid. Those are a little bit generally more understandable, I think, for the clients, but it's the soft ones where they're mainly afraid that they're going to trip into a recourse event because they don't mean to, and yet the contract is written broadly enough that it could become recourse. So I have to spend a lot of time talking them through why the funders want to, and I'll let sort of Chad talk about this in a minute from the funders perspective here. But we usually will talk to them through, well, should we add materiality qualifiers? Should we add in some type of intentionality or some knowledge-based qualifiers into some of these provisions that are triggering the recourse? And so it becomes a bit of an educational process at the beginning after we sort of peel them off the ceiling initially because they really weren't counting on that. And then also just explain to them that recourse, unfortunately, is part of this industry because the funders have to, hedge certain of their risks.
So Chad, but before you take the funders rule, I typically what I say to a client is, look, what we're trying and what the funder is trying to protect against is truly bad acts. And to Michael's point, perhaps intentional or knowing acts, and to try to carve those out so that there are cure periods and other things that are going to protect that client in the event that there's a foot fault or otherwise. What do you think?
I think we're not trying to take people's houses. Right? We don't make money taking people's houses away. Deals that go south or go sideways are not good for us any more than they're good for the counterparty or the funded party, whatever phrase you want to use. So what we do is we're in the business of assessing risk, right? When we look around the room, everybody knows this. Lawyers are not so much in the business of assessing risk. Sometimes they are, but that's how we price things. We price according to risk. And so when we come to recourse provisions, and the point here really is not to talk about different kinds of recourse provisions or what language can you use to structure a recourse provision. We could do that all day and we'd never get to drinks. Oh, there are no drinks. Um, It's more of the expectations in the funding process. And I think that's the thread that you're going to see run through the discussion today. How do you prepare counterparties and lawyers and others in the way Michael was talking about to understand what it is that we do and what it is that a funding agreement will look like? And for the most part, that is a non-recourse agreement. If you lose the case, the funder doesn't get paid. And if you win something or settle for something, well, hopefully the funder does get paid. So when we look to sort of the recourse provisions, and sometimes there are none, candidly, sometimes there are none. There are a couple of things that the funder thinks about and that any funded party or lawyer in the structure should understand. If we think that there is a specific risk because of the nature of the funded party, corporation versus individual, type of individual, portfolios of cases, if we think that there is a specific degree of risk, and if that is not as it is represented to us and there is some willing misconduct, willful misconduct, we're going to want recourse for that kind of thing. Sometimes there will be instances where we are willing to advance certain amounts of costs. We may be willing to go to X early in a case or series of cases. But if there's risk associated with going farther than that, we may attach some recourse collateral provisions to going more in order to get the deal done. So that's the environment in which we look at recourse economically. This is a deal after all. It's just a financial deal. Don't take that the wrong way. It's more than that. We love our clients. But in the end, it's finance that we're talking about. The final point that Michael and Andrew raised is bad boy provisions. Now, you heard the panel earlier talking about why there should be no outside capital in law firms because some lawyer in Florida got sued and there should be no investment banks or capital markets firms because Bernie Madoff did the wrong thing. We don't expect that. We do expect that people will behave in an honest way and with integrity. And if that's not the intent of the counterparty, then there are going to be provisions in there where those are willfully breached, where we will have other remedies. But I would suggest that's not unusual in the litigation finance business. That's pretty commonplace across the board in the capital markets. So for me, this is something, this notion of recourse that scares people because they read headlines about one funder who shall be unnamed here using recourse and then tricking people into breaching the contract. Yeah, okay, there's unethical behavior, there's untoward behavior through every industry and every market, but that's not what we do. So to me, the recourse is a very small part of this, and it's to protect us, and it's to ensure that the deal goes forward as the party should anticipate.
Yeah, I would just add, I think that sort of building sort of the funded party trust for funders is oftentimes the biggest challenge that we have, right? Because they, they feel that they are at risk every time they hear the word recourse. And yeah, the funders will tell them, we're not going to act precipitously on exercising this. But yet, of course, if you're the small inventor, you're the small company, even the individual, you're very concerned with what's going to happen to your family and your small business and your employees and things like that. So, part of my challenge in representing funded parties is really trying to, number one, find language that creates the right balance between the goals of the funder and the protections a funded party needs, but also trying to build a certain amount of confidence that these funders aren't in this to take advantage of you or to screw you. They really want to fund your case, but they have to protect themselves in some fundamental ways from kind of bad behavior.
Yeah, and you and I've had this conversation, and my answer to that is that's exactly why God invented Michael Kelly. Right? And I say that to make, I'm being a little bit funny about it, but that is true. That's why good lawyers do their jobs in these transactions.
Michael just said it, right? It's trust. And so there's this idea, and that's where I think a lot of us come into play. You can't have trust without education, without understanding. And so whether it's transaction counsel, whether it's broker, whether it's the funder itself, or all of us involved, you're trying to educate the party that's coming into this that knows the least. And oftentimes that's the funded party, right? And so I think that there's this idea, this bad boy provision style
that is the key. The first reaction you get, what? Oh, no, right? We've all been on the receiving end of that. And I think the idea is the education. And, I echo what Michael's saying in terms of the materiality and things of that sort. You're trying to level the playing field, but a lot of it, and I have to say, the funders have done an excellent job that I've been involved in, and the counterparties, if we're on opposite sides, in terms of educating patiently. We want this deal to move fast, but if you don't explain and you don't educate that funded party or soon to be funded party, you won't get there. And I think the key is for them to understand, we live in this world. They don't usually. A funder, for the most part, is not going to go after anybody, just to, Chad's point. That's a bad situation that no one wants to be in.
Right.
So, but there have to be some sort of protections. And what you're going to hear from us all throughout the rest of the panel, and I promise it won't be too long, is risk shifting. We're talking about risk shifting. What's there? What can we allocate? Keeping in mind that the leverage varies depending on the type of funded party, right?
Yeah, and just to build on what you've just said, I think there are market forces that also prevent funders from necessarily pulling out the rug from under their counterparties. Word does get around rather quickly, and if
Yep.
you're quick trigger your recourse, that certainly could be damaging in the market. So let's assume for a moment, issue 2, we've got our client comfortable with the recourse provisions. After a while, we peeled them off the ceiling. They look at the contract again and they say, I understand that the funder has no control over this case whatsoever. It's probably in all caps in the contract. They're comfortable with that. Then they reach these provisions where they realize that the funder has the unilateral right to stop funding the case, which would be pretty devastating in almost all of these situations. It's a surprise. It's obviously going to have to be managed. We're going to have to be very careful about when that can happen, how that happens, and especially what happens if the funder and the funded party disagree. We can all appreciate that good money after bad is not anything anyone's looking for, but especially if there's a disagreement between the parties, it's a real issue. Erica, can you be the funded party, and Michael, can you be the funder?
Sure. So, I think in these scenarios, we have to differentiate control directly versus indirectly. And I understand the question and how it's been framed. And I think the idea here that we're really driving as, you said the good money after bad, material adverse cost, material adverse event. Has there been a material situation that has shifted the dynamic? These are usually pretty egregious, pretty rare situations, but they have to be discussed and they have to be addressed. We do also try to address this in terms of proportionality, right? Some sort of reps, warranties, covenants on the part of the funder. We want to make sure that that doesn't happen. And again, for the same reasons Andrew just said for the first question, a funder is not going to be in business very long if they're pulling that proverbial rug out from under their funded party. It happens once, happens twice, no. So, but it's again, it's an education, and it's a situation where we're trying to get as much proportionality as we can, understanding the leverage, understanding the market, right? But that's really the conversation that's taking place. And it's shocking at first, but I think we get there eventually. These
Sure.
deals close.
Yeah, so if I'm on the funded, if I'm the funder in the funder shoes, I'm going to be concerned about material breaches. So particularly if I haven't been disclosed some material information that was really important for me in making my funding decision. So if I find out later on that somebody didn't own the patents that they claim they own, I need to terminate that funding right away, right? There's no point in me continuing to put good money into the case. In the calculus of funders' decision, it is the merits of the case, it's damages, it's the ability to recover those damages, but it's also who are the attorneys working on these cases. And so if the key attorneys withdraw, or if somehow they're terminated by the client, as a funder, I'm very concerned about that, because now what happens to my investment? Because suddenly my top choice for attorneys is walked, and how do I end up kind of getting that situation back in some order again? I want to have the right to terminate, because one of the key components of my risk was this law firm or this set of attorneys, because they have some maybe unusual expertise or just had some particular success with the defendants in a particular case. So, you know, I want to make sure that I have the ability to terminate if there's an issue with the attorneys representing the plaintiffs. Also insolvency, right? I mean, no funder wants to continue putting new money into insolvency or bankruptcy. I mean, most of the funders do try to structure their deals with sufficient working capital in the picture where the funded party is already on the balance of being perhaps solvent or insolvent. And they want to make sure that company that during the course of the funding remains solvent. But nevertheless, if insolvency does occur or there's an involuntary bankruptcy, or the company decides I'm going to go into voluntary bankruptcy, the funder does need the right to terminate. So that's really a very, very often a key provision. The most challenging of the termination rights that I will sort of as a funder, and then of course representing funded parties, is this whole issue of there being some event in the court case that reduces the merits or the chance of being successful in the case, or makes the recovery of the proceeds I was expecting materially changed. So if I'm not going to be able to, certainly I can't get my money back in a case, or if I'm not going to be able to get some type of return that I was expecting, I also look for a right to terminate, because I don't want to keep putting money into a situation where I'm just not going to be able to get the recovery of the calculus that I went into the case. And you know, as a funder, I've seen, you know, representing a funder in this conversation, I've seen different kind of provisions. Sometimes parties will say, I want the right to terminate if I don't get 3x. Sometimes it's 1x. Sometimes it's an amount to get, you know, my money back plus a reasonable IRR. And some funders say, I want the right to withdraw if I don't believe I'm going to get my money back. So there's a range of approaches on this, but the bottom line is that the funders do want the right to be able to terminate and walk out of the funding obligation if in fact the merits and damages change materially.
So Michael, a quick question for you and then one for Chad. So to me, the issue is that there's a disagreement between the funder and the funded party. And in the UK, where I started, when we had this issue where barristers are gods, right? There would be a provision in the contract that says if there's a disagreement, just go see the barristers, they're perfect and they'll figure it out and they'll decide who's right. And that worked, at least in the UK. In the States, it's this sort of unilateral right tied to a MAC provision or what have you. And you're right, there can be a multiple of what the return might be. But are you open as a funder to the idea of maybe arbitration or some kind of third party settling that dispute between the two? Because it's the control, it's the unilateral right of the funder to do that that really puts the funded party in a desperate situation.
I guess again, looking at it from the funder's perspective, you know, I need to sort of have the automatic right to stop putting money or an obligation to put money in, you know, because meanwhile, the case may be going forward, attorneys are incurring fees and costs that I've agreed that I'm going to pay for. Will the arbitration be able to be decided fast enough? You know, am I going to have some obligation to keep funding until that's resolved? I think probably for most funders, they would say, I'm going to terminate funding. And if for some reason I've done something wrong under the agreement, then we do have a broader arbitration clause that would allow the party to take this type of issue, you know, to an arbitration. But I don't think funders will want to be in a situation where they have to keep funding where one of these events has.
I know
occurred.
they won't want to, and we'll talk about power and the negotiation in a minute. But Chad, just any quick thoughts and any ideas about funding tied to settlement or any other provisions of the agreement?
I look, I mean, this goes to the relationship between a funded party and a funder, and whether you trust that the funder knows what they're doing. So when I look at cases, part of what we talk about and part of the people who are good in this industry, there has to be some faith in the notion that we've been doing this for a long time, not just as funders, but as lawyers. So I'm more than happy to have a discussion. I think funders should do that, have a discussion about what the nature of a material adverse event is, what means the case is going sideways, and sometimes to delineate them specifically or within a range, and those are fair things to negotiate. But at the end of the day, and this is an issue, what Erica calls education, I just call it understanding and basic competence if you're going to practice and be in this field. those of us who have done this for a long time have a fair understanding that there are hiccups along the way. And when you lose a discovery motion, that's not a material adverse event. If you lose a summary judgment motion, that's probably a bad thing. And so what we look to along the way and along the continuum of those events that can occur is to come to some meeting of the minds with Michael Kelly's as lawyers and the funded parties as to what this case is going to look like and what is going to cause a real and material decrease in the value of the investment. And I think if you work with a funder has some good experience in this kind of thing, while it can be scary and there can be a lengthy negotiation about this, there's usually a fair amount of common ground in this as to what is going to go wrong that could cause this case to be a loser. We're fully prepared to understand that not every case is going to be a 5X. What I won't do is underwrite a path to 0. And so we'll have that discussion in all of these cases. And at the end of the day, yeah, we're probably going to want a fair amount of discretion for some of the reasons that have been discussed here to go to the lawyers and say, look, this is what's gone wrong. This is really bad. And then we'll listen. But at the end of the day, I'm going to trust myself to know whether this thing has gone wrong, because one thing I do know is we're not looking to get out of the case. That's not a good thing for us. And so if we're going to make that decision that that kind of material adverse event has occurred in the litigation, we're going to focus pretty hard on that and be pretty certain that we're right.
So yeah, just a real quick add in, a related issue to this whole termination is, well, what is the remedy when one of these events occurs? And that is one of the largest, is a conversation I think that I get involved in a lot of these deals. For a lot of funders, particularly, you know, this last issue of there being an issue with merits or not enough proceeds, and they decide to kind of walk from the case and lose faith in the case. You know, the funded party may feel, I still believe in this case, and maybe even the attorney still believe in this case. But, you know, where will it, is it really fair for the funder to still expect to receive a large return where they've kind of said, I don't believe in this anymore? Are they entitled to get kind of their full return? Should they get something less in that circumstance?
I can give you that answer if you're ready for it, but never mind. Keep going. The answer is not,
And I
not at
think,
that point.
but those are key components to the discussion at the outset, right? Because those are the provisions we labor over. We look, if this does go sideways, we hope it doesn't, it probably won't, but if it does, what is the expectation? What will happen? You know, and delineating the definition. There are a lot, it's hard to define a material adverse event. I know Chad quips that it's pretty easy, but there are aspects in some of these cases and nuances that are complex, right? Things happen. So it behooves us to at least have those conversations and to understand. And to the point on the arbitration, the overall general arbitration is not necessarily going to make sense. If your money's been pulled, you're not going to have a side arbitration to try to figure that out, because where are you getting the funds from, right? But there are aspects that could be written in, and we've done this, not very often, but we've done this, where you have an expedited arbitration. The arbitral institutions have them very quickly on the papers or not. Under, you know, you can write those in if that is really a concern. And if that's going to get you over the line, maybe that's what you do. I'm not saying it makes sense for every contract.
All right, I'm gonna move
By
to-
the way,
Sorry, Chad, go ahead.
I never quip.
I was just making sure you were listening.
All right, on to our third issue, and this one is, again, unique to litigation funding agreements. It's a rep that is, in my experience, almost always negotiated carefully. For context, these underlying litigations can take years with millions of documents and endless motion practice, and they can typically be very complex commercial transactions in litigation. And yet, often the first draft of the contract from the funder arrives, and there is a provision that reads more or less, Mr. Counterparty, you have shown us all of the documents that are material to the case, and you've told us everything you know that could impact our decision in any way, haven't you? And that's usually a pretty fraught moment for the client. If they say, yes, of course I've done that, they can hardly remember what they've told you. And if they don't agree to that, well, or rather that they do agree to that, the fear is that the funder is going to find a way to bring that against them if the case is not successful. So let me ask Chad to play the funded party and Erica to speak for the funder.
Before I answer, we need to turn the camera off.
Yeah.
So from
I know I'm
the,
putting Chad in a tight spot here.
from
You
the-
can do it.
from the funded party's perspective, and I think this is from the funded party's perspective, but also from the lawyer's perspective, the lawyer for the funded party, which I can speak to maybe a little bit better, having done this for clients. One of the things that annoyed me when practicing law dealing with funders, nobody anyone here would know, is when we would get these silly requests from people who had been practicing law for 4 years and then went to funders, and they would ask for all sorts of stuff. And I would say, what do you need this for? Is this, you don't trust me?
Mhm.
And then we would get these kinds of provisions for tell us everything and swear to me 3 times on your entire family's great that you've given us everything. And there would of course be a discussion about that. Of course there would. But I also knew pretty clearly if I trusted the client and I actually understood the case, and generally I liked to think that I did, that there was a certain amount of material that you had to hand over in order to give a funder comfort with the case and to actually get the money you wanted. Because if you didn't do that, you were never going to get the case funded in the first place. And so if you work as a funder with lawyers who you know and trust, and I don't want to step on the other side of this argument, if lawyers work with funders who they know and trust, and the funders have a trusted relationship with the lawyers, this is less of a problem for funded parties and their lawyers because we understand what it is the funder is looking for. And so if you want to talk to me as a funded party and the lawyer for that and say, if you don't represent to me that everything that I, the funder, might consider material later on, my answer is going to be probably not so much. But if we want to craft language that says, have you been straightforward and forthcoming and fulsome in your production of information and details? Well, that's what I would do anyway, because those are the kinds of things that are in my best interest as the lawyer and the funded party. You should go into the transaction and the trade, understanding that's what's expected of you anyway.
So, and I think what you hear here a lot is what's the goal, right? Sometimes these provisions, especially when they're first read and as the funder wearing the funder hat, what do you mean? Of course, I want to see everything, know everything, and make sure that I've assessed my risk properly, right? But if you can't represent to that, that gives me pause. That gives me concern. On the other side, obviously, in the funded party, how do I know? I think I've given you everything. Are you really going to read it all? Come on. And so the last thing you want to hear is trust me, trust me. But if we're in this business and we're working with people that we know, there is an aspect to Chad's point where you've given us, we all have to do our parts, right? We have our diligence process at the funder. We have to do what we need to do, but we're a team at a certain point. Once we've gotten past this agreement, we are operating in a team-oriented fashion. So I think on this tell us everything, depending on the relationships involved and the like, yeah, there will be a little bit of wiggle room, so to speak, of what's the goal? The goal is I want to make sure as a funder, I've done my assessment and my diligence based on everything that is important and material. And if there's something that you hid or that is hidden, that's a problem. Now, from the funded side, maybe the way that you deal with that is, yes, everything that I know of, I've told you, right? So you start to kind of figure out a way that you address and meet the goal and get both sides comfortable with the language that is in front of them. And that's sort of how we.
Can I add one thing? Now you can turn the camera back on. One thing that I think is worth understanding as we talk more about process, and again, that same thread I keep talking about is, if you're, from the funder's perspective, if you're any good at this and you've done this for a while as a lawyer, you should kind of know what questions to ask, right? Now, you may not always know when someone's lying to you or withholding, but I didn't spend 30 years not knowing when people weren't being straight with me. I had a pretty good radar for that kind of thing. So yes, there are going to be some reps and warranties in there that you didn't lie to me, but part of the job, and on both sides, people have to understand this, both sides of the trade, it's fair to understand that if we're any good and we're professional, I have a pretty good instinct about what the documents say and where to ask questions and where to ask for more. And we have due diligence checklists and we have material document requests that we spend a fair amount of time putting together. We're not trying to get away with something, and the client probably shouldn't be. The gap between the two isn't as wide as this more philosophical discussion might be if you're dealing with professionals. And again, I keep coming back to this theme. If you're good and competent at what you're doing in the space, you should understand going in that this is what this is going to look like, and it probably works out in the end, unless you're really dealing with those sort of outliers of dishonesty.
Well, outliers, sorry, of dishonesty
Time
and or,
cop in a sec. Keep
okay,
going.
one second. But, and also people who have no conception of what's going on. And from the outset, if they understand and they're never going to get to that comfort to be able to sign an agreement that has a rep and warranty of this nature, maybe a little bit melded down, then maybe funding isn't for them. Maybe there's another process that they should be going into. Sorry, but there is that aspect too. I've seen it very rarely, but it happens.
Fourth issue, and then we're gonna go to our lightning round. And this one is actually new to me, and forgive me if it seems a little upside down, so bear with me. The issue is what I think we're starting to call the ethics rep. And this is a general rep that's asked of the funded party. The funded party is asked to represent, if they have reviewed, and this is from a contract I received recently, all applicable professional rules, and each provision of the agreement complies with disciplinary rules, and there's nothing here essentially that's against public policy. And they're asking that of the funded party. The funder is asking that of the funded party, who probably is doing this for the first time. So, question to Erica, if you'd like to be the funded party and express some outrage, I'd be happy with that. Go ahead.
So I will express outrage and I will put on the hat of the internal firm GC potentially. What? No, no way. Find another way. No, because it's a problem. So this risk shifting, and the funny part too is the funders have the repository of the research, the information, they know what they're doing. But what are we trying to accomplish here? There's a shift, there's things that are going on, there are things that we don't necessarily know about. The rules are changing all around in terms of disclosure. The rules of professional responsibility for the most part are stagnant, they're staying the same, but we don't know the interpretation by the various ethics opinions sometimes. There are things that are happening and that are okay, and yet we don't know if they're really okay. And so this shifting to the funded party, what's behind it? This is what's really behind it is, I don't want to be in a position where at the end of the day, we have a successful recovery and you pull ethics card on me and you don't pay me, right? So understanding what's behind all of this, it's a conversation, right? Where we say, okay, I know what you're trying to protect. I can't agree to that.
So Michael,
So what do you do?
How do you, how do you as a funder deal with that?
Well, I mean, I think the concern that Erica explained is sort of the pulling of the rug out at the very end and sort of finding a basis for not paying
Mhm.
the proceeds once the case is successful by arguing there's champerty or there's some impermissible fee sharing, or maybe this is just generally against public policy as a way not to pay. So I think that's obviously the funder's perspective on it, and the funder's practical concern. You know, I think this is a provision, if I'm sort of just in this industry generally, that I'm very kind of uncomfortable with, right? I think it's almost that, you know, the funders do control all the information generally, and they should have, this is their industry. This is what they should spend time studying and being advised about. So can they use this as sort of I guess a shield against funded parties in some way? And it's when I've seen it sort of imposed onto funded parties, I get uncomfortable with that, because I think it appears to be sort of overreaching and sort of belies, you know, what funders should be doing every day. And that's understanding the ethics of the industry that they're in. You know, I do think that, you know, I'd almost rather the contract stay silent on this issue, you know, rather than trying to shift the risk. I just think it just puts the funded party in a very uncomfortable situation. But I do think funders are concerned about strategic revisiting of this as a way to not have to pay in the end, or at least to delay payment, raise a doubt over the payment to foster a negotiation that would then change the economics post judgment or post settlement.
And I think what's important to understand from the funded party perspective, especially, I know in the scenario at the outset, we were saying it was the client, but if it's the law firm, these are ethics rules that govern the practice of law, practice of the, it's not just the lawyer, it is the law firm. I know we were talking about different things in an earlier panel, but it is not going to be good for either the lawyer or the law firm if there's an ethics violation, right? Or if there's some sort of an issue. And these negotiations for a law firm and a lawyer, if they really think through the ethics rules and go through bit by bit, it's stressful. I know the funders like to smooth over sometimes and say, oh, it's fine, it's fine. Yeah, we've gotten to a point of comfort. We're working our way through it. But if all you do is work inside an in-house counsel's perspective from a law firm, there's nothing good here. It's scary, right? It's a scary place. Now we have conversations, we educate, we get there. But just from that perspective, the optics initially, they're not so great. They're hard.
What do you think, Erica, about maybe a slightly different approach? And that would be creating a waiver in the agreement, effectively asking the funded party to waive that as a defense, waive, fundamental disciplinary rules or the assertion of public policy as some defense to payment.
I think depending on how it's crafted, it's a potential, right?
Mhm.
I always get nervous with some of these waivers and I don't want to stir into other clauses, but sometimes when we see these waivers, they can be a little too broad. So again, it depends lawyer answer. If it's crafted narrowly to protect against that ripping of the rug from out from under, yeah, I think that it could be there. Now, query how enforceable some of these things would be. Sometimes we're on these calls and we'll say, even if you can get this in and we agree, is it enforceable?
Right.
That's another question. So in theory, yeah, if it's narrowly crafted, maybe a waiver to that sort, because it's getting us to the same goal. We have the same understanding. Neither side wants to be at the position where we finally are successful. And then there's a little bit of a change that's not right.
Chad, you don't want to touch this one, do you?
Sure,
Good.
why not?
So, go ahead.
Ethics can be difficult, but again, I hear myself thinking and saying a lot of the same things when I'm weighing in now, so please forgive me, and I'm not usually this boring. We try to spot these issues early on. I mean, like I said, I've been looking at these ethics issues for a very long time, but nobody's perfect here. And so where issue spotting is somewhat successful, we call other people in. Tony won't work for me. That's too damn bad. But we know who to call to address ethics issues. We will sometimes ask a client to provide an ethics opinion. We'll get an ethics opinion. We'll figure out how that's done. But you can spot these things for the most part early on. The bigger problems, I think, occur where the client, the funded party, or the lawyer is very unclear about these things and asks questions like, is litigation funding really ethical? If you fund my law firm, what can I do with that money? Do I have to put it in an escrow account? Is it ethical to give any of that to the lawyers in my firm? Show me 100 cases that say that kind of thing. And this kind of thing happens more than you realize. The better deals are the ones where they don't, but we're not trying to transfer, in most cases, I think most funders don't transfer sort of this broad ethics risk, however you would define that, onto a funded party. I think the issue of you don't pay me at the end because of the ethics, that's a totally separate discussion. If you were asking me, do I want to touch this one about waivers of ethics? The answer to that is no, thank you, sir. All right.
Well, then listen, let's go to identify other issues aside from contractual terms that tend to slow these deals down. These things are, if not identified early, going to result in a delayed process. So I'm going to just quickly ask each one of you to address one issue and then maybe give us any other insights. Chad, I know you and I differ on this. The topic is the term sheet. I like to do a term sheet with economic terms and then hurry up and get to the contractual conversation because I know it's going to be long and I know it's going to be complex and I'm anxious to get to that conversation. My understanding is you'd rather actually spend time with a more fulsome term sheet because you think that's a faster way to get the deal closed, yeah?
Well, I think there's room for disagreement on this one. I think people of reason, people of goodwill can come to different conclusions about whether a 2-page term sheet or a 25-page term sheet is the right thing overall, or is it the right thing or not in a specific deal? There's no right answer to this. When I started looking at term sheets long ago, and from a funder that I know and respect, and it was a page and a half long, and I looked at it and I thought, what good is this? This is, you just want to lock in exclusivity and you want to get to the deal because you know you've got me. And what am I don't even know what I'm signing here. And I'm just a dumb litigator. I'm not even a corporate lawyer. And so to me, that doesn't solve the problem. Maybe there's an exceptional case where that serves its purpose. At the same point, for most funded parties and lawyers, sending them a 40-page term sheet for a deal is probably going to lose you the deal. That's my view. Others differ, but there is in between, whatever that looks like. And Michael and I have talked about this. There is the type of term sheet that lays out the expectations of the funder. It addresses the key items with some degree of clarity. And if the client funded party reads it and the lawyer reads it and is good with it, by the time it's negotiated, the odds of having a real problem down the road, I think, are materially reduced. And so that's the point for us, getting to a point where we know we have a deal that's not going to bust, that I'm not going to have to chase after somebody, and that we're being straightforward and transparent with each other, and we can get to the deal. That's the way we view the process.
Yeah, I'm a huge fan of more.
No, it's a lightning round, only one.
Oh, sorry.
No, we got
Sorry.
Right. So I do have a question for you, Michael. My question for you is this, and I know you and I have actually had this recently.
Right.
But when you go to do a first draft for a funder, first question is, what's the structure of the deal? Is it going to be a prepaid forward purchase? Is it going to be a loan? What exactly is it going to look like? That typically is driven, as I understand it, by tax considerations. Is this an important thing for us to identify early on, or where are we?
I mean, I think there's two issues here. One is just, funders have different approaches, right? So, sort of credit-based funders prefer to use loan agreements. That's kind of their preferred approach. And because they come out of an industry or business that's more extending credit. There are other sort of more traditional funders, I think, who will use sort of prepaid forward purchase agreements. Early in my practice, those seem to be quite popular. There was a period of time where they became a little bit less in the picture, but now they're coming back again. And then, of course, there's genericized investment agreements or, case proceeds investment agreements. I think the bottom line is that when you look through all these forms of agreements, they basically contain the same sort of fundamental economic terms. You can replicate the economic terms from a term sheet, whether you do this as a loan or prepaid forward generally, or as sort of just a general investment agreement. But as Andrew was alluding to, there are some tax differences. And I think, funders may prefer certain forms of agreement because they prefer a certain tax treatment of the transactions. For most funded parties, they don't have any idea what the impact of one approach may or may not be on their taxes. So one of the things I do try to ask my clients when I'm representing them as a funded party is, number one, get some tax advice about the structure of this transaction. How is this going to be categorized when you get the money in from the funder? Is this income right away? Is there any concern that you have about, a credit structure from a tax perspective? Prepaid forward purchases are kind of this exotic concept, right? And there's a variety of sort of tax views about prepaid forward purchase agreements. But I think that, getting a good tax advice is really important for the funded party as well. It's always a risk because they sometimes don't have the money to do that. So are they kind of having to jump into this a little bit exposed? Obviously, I'm not a tax attorney, so that's something I don't advise on, but I really try to make sure that the funded parties are very conscious of making a decision about this transaction, also taking in mind their tax position.
And Erica, when we're early in the process, usually there's a budget that's involved, a budget that we've gotten from the law firms. And there's a headline number for what's going to be funded, but it's more complicated than that, right? We've got phasing and other issues that have got to be addressed early on, or we're going to run into issues as we go down the process.
Budget? What's that?
So anyone who's gone down this path,
And this is where the litigators sometimes have a little trouble, but yeah, the budgets are really important and more we're seeing phased approaches, right? In terms of the funding. It used to be a lump sum of some sort. Now we're seeing more phased approaches. And candidly, from the business of law perspective, from a client perspective, that's nothing new, right? Doing work internationally, we've seen this a lot over the years anyway, so it's not something unheard of. But I think the key is understanding that you will be held to that budget. And what is the impact? The overage has to be absorbed by the firm or someone who's absorbing it. And so that really becomes the question. And I think making sure, and I do this a lot, making sure that that budget is informed and done well and broken down as best as it can, because you don't want a scenario where you've signed the deal, you think everything's great, and then you run over the budget. And the funder, if the deal is the deal, it's unfair, frankly, to be expecting the funder to continue to bail you out. That's irresponsible, right? And so there's a situation where, but the budget is important and sometimes really onerous. That's an arduous process. And you were talking about the deal taking too long. The budget, that can all be done ahead of time. Preparing the documents, right? Like all of these steps, if they're done and you know to do them from the funded party perspective, that makes the process go a lot smoother.
Yeah, and just in the interest of time, I'll just mention a few other things that really should be done at the get-go. And forgive me, I'm going to steal Michael's thunder here, but if you don't do a lien search right away to figure out if you need some intercreditor agreements, you're out of your mind, because it can really drag out the process. And it's wildly important to understand what you're dealing with in terms of liens that need to be, well, subordinated, in a word. That's one advice. The other advice is, please early on figure out who's going to have your escrow, or if the law firm is going to be using their IOLTA account. That is additional cost and or confusion and can also delay the deal. So in the couple seconds we have left, I want to ask each one of you just to give some quick observations on what you think might be going on with respect to standardized agreements, whether or not, given everything you've heard and the complexity of what you've heard, there's a place for that or something akin to those. And Chad, I'll start down there and we can work our way.
Yeah, I know what's going on. It's discussion. It's not much more than that. I think it was said a little earlier on. I forget who said it today. We're not at the point of standardized documents right now. These deals are bespoke, to use the word we hear all the time. There's too much in them that is particular and specific to various kinds of structures. The one thing that I do think that, whether you call it standardized or template provisions, that kind of thing can do, is to address what we were trying to talk about here today, which is to provide some level of reasoned expectation of what a litigation funding deal looks like in specific areas. And so, and then I'll stop. If you bring a really good, smart corporate M&A lawyer or securitization lawyer to this deal, this can be a travesty, because all of the things that they are trained to do and look for and demand from counterparties, like 4 pages of reps and warranties, don't fit. And so if you set the stage with some templated provisions along the way, and I've seen the agreements posted by a couple of firms, this is our template agreement. Okay, that's great. But we are at litigation finance, I don't know, 2.0, maybe 2.5 in the history of this thing, whatever it is. We're just not ready for that. We're just not a mature industry. Sorry if I'm offending anybody, but it's not a mature industry in the way that others in the capital markets are. So my own view is we're not at that point for form documents in the space.
Erica?
So part of the reason I wanted to do a panel like this and talk about this is the reasonable expectation, the education I keep saying. Because while I will tell you, I've seen nearly every funder's template, form, what have you. Some are styled differently, but a lot of these common clauses that we're talking about cause issues, consternation for the funded party at the outset. And so I think while we're not at a standardized point, discussion, education over some of these clauses and a back and forth a little bit is helpful. Will we get there? Maybe, I don't know. But I think the idea is really understanding what is in there. And your point in terms of, you know, the standard corporate lawyer and the like. Yeah, I've actually been on the other side of some of those. And frankly, the next time we go around, I've seen the provisions of that agreement incorporating my suggestions. So some of this is still flowing, it's changing because there are newer entrants. They're taking a credit agreement, they're taking an agreement that another standardized form and modifying it. But it doesn't necessarily serve the purpose. And a few transactions in, they realize, oh, this is a different beast. But I do think it behooves us to continue to have these conversations and offer the pragmatic experience that we have. That was really the idea.
Michael, you want to take us home?
Yeah, look, I mean, I think there's a couple factors here. One is, can you have standardization where you have, some fundamentally different types of claims? So, patent claims are very different than simple contractual claims, right? There's a lot of additional other reps, warranties, covenants, potential events of default, other things you would probably need to add in that you just wouldn't have to have in maybe a more generic breach of contract funding agreement. I think the other thing is it really depends too on who the funded party is. It's a very big difference between the small company versus the publicly traded company, right? And one of the struggles I see sometimes in this industry still is the ability of funders to sort of pivot their forms away from kind of the smaller company, kind of distressed company kind of model to really the well-heeled, sophisticated, publicly traded entity who's looking for funding to take something off their balance sheet and diversify the risk a little bit and to monetize assets they have. So, I think the different type of funded parties may also make it challenging to create standardization, but maybe it will come. I think we're still pretty far away in my view.
So that's the end of our panel. I'm hesitant to ask for questions just because it's the end of the day, but please.
Like to draw your attention. I would like to draw your attention about transnational arbitration financing. I've seen some cases, especially recently, from possible funded people who, after a very complicated due process, they receive the text of the contracts and they say, I can't sign that. Your contracts are very complicated. You repeat again and again many things. You need dozens and dozens of pages to say what we in continental law, we could say in a couple of pages. Do you think that probably you should think, if you want to be more aggressive in that kind of business, especially in international arbitration, that probably you should modify your way of contracting, or probably you should recommend your clients to domicile elsewhere your contracts?
I'm going to make a quick comment, then I'm going to ask Michael, who I think is best positioned. I just wanted to make the point that when I started 10 years ago in this industry, the real struggle was with the underwriting, because by the time you got a funder to agree to take your case, most people taking funding were impecunious or in a very desperate situation, and they were happy to sign anything, really. And that made the contracting process quite easy. Now, you've got more sophisticated parties who don't necessarily need this. They think it might be a good idea. They go through all the pain of the diligence process, and then sometimes they get a contract that is very difficult for them. And I'm seeing more things now fall apart in the contractual stage than I've ever seen before. Michael, I don't know what your thoughts are.
Yeah, I'm a huge proponent of just sort of plain language drafting. I think, especially for the type of a funded party that Andrew's just talking about, those who really don't have the means to spend, a lot of attorney time helping them to interpret the complicated documents. But the last thing you want them to do is just not to read the document because it's too intimidating, yet they're so desperate to get the money. I don't think we do ourselves any favors in the industry by making our contracts so difficult to read that maybe we're having some type of it's some type of power situation almost that's imbalanced between the parties that doesn't really need to be there. So I'm all about plain drafting, and I have seen contracts sort of founder where a party has not been able you know, they said, okay, explain to me, Michael, why this is still non-recourse. Because they see a lot of provisions that are concerning to them, and it takes me like 10 steps in the document, but with this provision, this provision, this, for this, and they said, this scares me, you know, and so then the deal does fall apart. And so I do think it is a good idea in this industry to try to make our documents readable. Doesn't necessarily mean they have to be short, but they have to be plain language and accessible, I think, for the parties themselves read, not just their counsels.
Do you mind if I just add one last thought to that? Bernardo raises a good point, but it's not unique to litigation finance. And I say this because my own history is spending a lot of time doing international litigation. If you are going to do what Bernardo suggests, which is to do litigation finance in a multinational situation, right? Then you have to, as a funder and a lawyer too, be sensitive to the legal system, civil law, common law, the culture of the country, and the legal traditions in which you operate. And so the notion that some funders may not be particularly sensitive to that, and the contracts are not well received, that doesn't shock and surprise me, but it's a fair point. Now, I think the relevance of that is, if this is 2.5, wait till we get to litigation finance 5.0, and this is in India, and it's in Asia, and it's in other markets that have not grown. That question may be a little less significant then, because we're going to have to adapt to it in the way international lawyers and international arbitrators adapt to their environment as practitioners, and either they do or they don't succeed. So that's part of the way I'd respond to that one.
I'd also say that back to standardized agreements, those tend to be more plain English, more user-friendly, and that's another argument to try to take what we're doing and put it in some kind of form that can be used that way. Anybody else dare to ask a question? We will be here afterwards, please.
From my experience in venture capital, I had a George Soros deal where I didn't realize that I had to pay for George Soros's lawyers. I was working a hedge fund deal, $250 million deal, where I found out that the cost of the attorneys and the accounting firm will be closed and paid for underwritten at the time of the closing. So in your transactions, who underwrites the costs of everything here? Because obviously I had a friend at General Catalyst who wrote a friend of mine, that the opposing lawyer negotiated for the investee so long that he got irritated, because in the long run, not only is he paying for his lawyer, General Catalyst, but also for his lawyer, and that's lesser money in the long run that's being funded. So how are these costs being underwritten?
That's a very sensitive question.
You want me to take
Would you like to try that?
Sure. I mean, I've seen an evolution in this over time, and I think part of this has to do with just how the market is going, but also there is a little bit of a competitive market now in our industry that is causing there to be a little bit different view on this precise issue. But I do think that from the funded party side, they are looking to get a substantial portion of their due diligence costs and their transaction fees recovered. That's their ideal position. Most contracts I'm seeing these days have some type of a cap. So it kind of depends maybe on the size of the transaction, what that cap is. But I think funders are increasingly sensitive as to, what kind of costs they are imposing at that moment. And they're also hearing that maybe their competitors are taking lower caps, and therefore it may make a difference in maybe which way which contract is basically accepted by the funded party.
The only thing I'll add to that, and it's important, is that most funders, if they really like the case, they're in for a penny, they're in for a pound.
Right.
Those transactional fees are arguably rounding errors on the entire commitment, and funders will usually allow the funded party to roll that into the funded amount. So there's no out of pocket right now.
Mhm.
At the end of the day, it's difficult, but it's not that taxing.
Yeah.
And if I might, it's also to the best interest of the funder to allow for that. I mean, from Bernardo's point, you need to make sure that the party that is on the other side, the funded party and or the law firm, understands that contract, right? In order for it to be ultimately enforceable. And so for all the reasons, it's a lot more than that, but So I think the use of transactional counsel, allotting for some transactional cap, and we see it for the funder too. In all the agreements, there's transactional costs for the funder. Now we're starting to see transactional costs for the funded party. We didn't always.
I think with that, I'll call it. Thank you so much to our panel. I really enjoyed it. And I want to thank all of you on behalf of the Center on Civil Justice. If you have ideas for future conferences, you can find my email address on the center website. And it's been nice to be with you. Oh yeah, you gotta sign out for CLE too. One more time.
If you want CLE, remember to sign out before you leave.